Hello and welcome. I have a very enlightening show for you, an enlightening guest. I'm speaking tonight and visiting with Jill Hasday. Jill is a professor. She is at the School of Law, Minnesota University, and she's written a book that I have found very, very interesting called Intimate Lies and the Law. And we'll get into a lot of detail with the book. But first I want to tell you a little bit more about Dr. Hasday. She's been at the university since 2005. She's a graduate of Yale and Yale Law School. She clerked with Patricia Wald at the DC Circuit of the Court of Appeals. You've taught in other settings too, but you've been here now a long, long time, and she's been very honored and revered here. She is the distinguished McKnight University professor, also Centennial professor. She's gotten lots of awards for her work. She teaches, I think, 4 or 5 different subjects. Do you want to share the subjects?
I teach family law, constitutional law, sex discrimination, employment discrimination, and a public law workshop.
So kind of cover a lot of waterfront. The book that we're talking about tonight probably springs from your background in family law. Am I correct?
Yep.
And her premise, if I can state it, and we'll be sure that I'm stating it correctly, is that the law really has denied remedies to people who have been deceived in intimate relationships. And this includes judges, attorneys. It's become kind of a pervasive cultural approach. And Dr. Hasday is writing and talking and speaking out about how this must change. One of the people from Columbia Law School who reviewed the book wrote that this book has the potential to reshape not only the legal terrain, but the very human relationships that live and breathe in the law's shadow. And I found that very perceptive, and I thought, I think that professor is correct. This book could be a breakthrough, really, Dr. Hasday, in the world of law, couldn't it?
I hope so. I appreciate that.
Yes, it's an exciting read for that reason alone. What led you to tackle this big topic, and a topic that's not been tackled much?
Well, I think it's a good time to share the dedication to the Intimate Lies in the Law. I dedicated it to my loved ones. You did not inspire me to write this book. So the inspiration for this book didn't come from my personal life, luckily
so you've
for
not
me.
been the wronged, deceived
luckily not.
person.
Instead, it came from the time I've spent teaching and writing. In family law, I would occasionally come across these cases where a deceptive intimate inflicted enormous damage and got away with it because courts weren't willing to let the plaintiffs access the ordinary remedies that the law makes available for deception in other contexts. And I just thought that was very interesting, and I kept it in mind as something I wanted to go back to.
And it's something that has changed in our country too. I mean, as I learned from your book, the law was a little different back 100 years ago or 75 years ago in the way it looked at deception and strangers versus intimates, right?
Well, one thing that's interesting is the remedies for intimate deception have actually shrunk over the last 100 years or become less important, and there's a few reasons why. First, starting in the 1930s, states passed a wave of statutes that were called anti-harpam laws that prohibited suits for seduction and breach of promise to marry. These statutes sound like dusty relics, but in fact, courts continue to rely on them. If you were once engaged to someone and ultimately didn't get married, courts won't let you sue for any kind of deception, even if unrelated to the broken engagement. In fact, even if you get married, courts will sometimes block you from suing a deceptive spouse on the theory that this is a breach of promise to marry claim in disguise, even though there was no promise that was breached. You actually got married.
And so this is true today,
Today, yep.
but it wasn't necessarily true back in the 30s.
Through the 1930s, you had women suing where their essential claim was, you deceived me into having sex by pretending you were going to get married. That was a viable claim through the 1930s, and then courts eliminated, and now modern courts interpret those prohibitions as broadly as possible. So if you were ever engaged to someone, that's it. You can't sue them for any kind of deceit.
When you write about deception, would you just define it in the most basic way?
So
Jill?
by deception, I just mean intentional acts or omissions, including statements, deeds, silence, designed to make someone else believe something that the deceiver thinks is untrue. So lies are probably the most common kind, the kind of deception that springs first to mind, but deception can take many other forms. So deliberate omissions designed to mislead are probably more common than lies. It can serve the same function. For every adulterer who lies to conceal his affair, there's probably many more who deliberately don't mention their fidelity to give their spouse the wrong impression.
I was listening to the radio kind of in the background today, and I heard the announcer say, there's been a new poll on lying. And I rushed out and heard just the tail end of it, but what I think I heard was that 1/2 of the people who were polled admitted to lying. And I thought, I wonder if that number is getting larger in our society, or if you have any research on that.
Deception is a robust phenomenon across time. I think it's tempting to say, oh, back in my day it was better, but deception is a very robust phenomenon. People lie all the time. In the book, I'm not interested in lies that were in both people's interest, including the deceived person. So as I say in the book, if you want to lie to me and tell me you enjoyed reading my book, I'm delighted to hear that. That doesn't hurt me. I'm focusing on lies where the deceiver feels injured by the deception.
Right.
It causes injury.
And you're talking about lies that might have to do with money, might have to do with property, might have to do with sex, not just intimacy, correct?
Right. I mean, people can lie to their intimates about anything from fidelity to finances, marital status to military service, anything you could care about. When I started this book, people would ask me, what kinds of intimate deceptions do you find the most surprising? In the beginning, I was surprised all the time. This person has a secret second family. How do they manage the logistics? But at this point, I'm not surprised anymore about anything. Anything you could imagine, anything that might matter to one or both people in a relationship has been the subject of intimate deception. The list is endless.
Did that depress you? Or make you more cynical, perhaps?
There's this very interesting memoir. So in addition to reading all the cases I could find, I read hundreds of memoirs and interviews, and there's this very interesting memoir written by this man who discovered that his wife had been having a secret affair for years. And like many people in that situation, he said, actually what hurt my feelings most was the deception as opposed to just the infidelity. And he said, on the one hand, I feel like I have a more realistic sense of how easy it is to be fooled. On the other, I want to trust again to have a new relationship. And I would hate if someone would read this book and say, the solution is never to have an intimate relationship. Intimacy benefits the people in it, society. My point is more that we should want people to trust, and we should protect them when they trust and it turns out to be they're trusting a deceptive person.
And I believe you make the point, too, that when the law has been skewed in a sense that, as it has been to protecting the deceiver, that acts as almost a societal kind of motivator for more cheating, doesn't it? And more lying?
Right. One thing that's interesting is, in general, the law pushes people towards, we want people to trust. That helps relationships. But in this context, courts are to the extent they intervene, they create incentives to deceive because they help you get away with it.
The deceiver, maybe consciously or unconsciously, knows that I can probably, as you say, get by with this.
And even if I'm not claiming that everyone knows exactly the law, but I think people do have a sense that there just aren't. You don't hear a lot of cases where someone is held accountable for deceiving their intimates.
Right. Yeah, that makes a lot of sense. What are some of the ways that you see people that you've read about all these hundreds of cases feel injured or feel that they maybe have a right to do something about it?
Well, the injuries range, but they can be severe, even life-changing. So they include financial harms, illnesses and infections, violations of sexual autonomy and bodily integrity, lost time, missed opportunities, and of course, emotional pain, distress, and devastation.
And that one would be maybe underline most of the others too, in a way, right?
Right. But
when you've found out you've been deceived.
Right, but what's interesting is often emotional injury is paired with other kinds of injury. So for instance,
yes, it is.
Infidelity can be emotionally devastating, but it's also very expensive. As someone that has secret assignations with their girlfriend, you know, they're spending a lot of money. There's often a lot of financial harm wrapped around the emotional injuries as well.
Right. And we also hear emotional distress used in all kinds of other cases. Car accident, house burning down, et cetera, et cetera. So that's something that's carried across all kinds of cases.
Right. I mean, one of the basic thrusts of the book is I think deceived intimates should have access to the same remedies they would have if they were deceived outside of intimacy. So if you could sue a stranger for fraud or battery or misrepresentation, you should be able to present the same evidence and bring the same claim against a deceptive intimate. In general, tort law is more protective of financial and physical injuries compared to emotional injuries. So even under my approach, deceived intimates are going to be more likely to get redress if they have financial or physical harms. But my idea is that right now, courts will categorically bar someone from bringing a claim, even when they have all the ordinary elements they need to prove. They'll say, oh, you were deceived by an intimate. And I want to stop that. I say, you know, intimates should be able to access ordinary law and deception.
So the door is shut before there's even a chance to plead your case, right?
And I can give you an example actually of that.
That'd be great.
This woman, Paula Bonham, she connects with this man on a internet chat room. Over the course of almost 2 years, they exchange endless emails, phone calls, packages. She sends him more than $10,000 in gifts. And he puts her through the emotional ringer. He says he's dying of liver cancer. He's tried to kill himself. Because the story's in my book, you know how it ends. She discovers he doesn't really exist. She alleges he's a fake persona created by this woman named Jana St. James, she says, to manipulate her emotionally and financially. Paula sues Jana in Illinois, and her claim seems to satisfy all the ordinary elements of a claim for fraudulent misrepresentation. The defendant lied, wanted the plaintiff to rely on her lies. The plaintiff did reasonably rely, and she suffered injuries. But the Illinois Supreme Court says you can't sue because you were deceived by an intimate.
So it went all the way to the Supreme Court, though, right?
But you can't sue. So I think there's at least two things that are interesting here. One, the bedrock idea intimates can't access ordinary remedies. And two, courts are willing to define intimacy broadly enough to cover two people who didn't even meet until right before the deception was unveiled. In the romantic and sexual context, courts will treat people's intimates actually when they really don't know each other very well.
And why? Here is my probably most curious question, Jill. Why have the courts been taking this position to the degree they have?
You know, what's interesting is courts generally do very little to explain their persistent differentiation of intimate deception. They either assume it as common sense, or they sort of vaguely reference the idea of not intervening in intimate relationships. I don't find these arguments about not intervening very convincing. Whether courts rule for plaintiffs or defendants, they're setting the legal ground rules for intimacy, deciding who counts as an intimate, what's acceptable and what's not. It's just that now courts are doing it in a way that protects deceivers.
And they, of course, then are less flooded with cases. Are they worried they're going to get an onslaught of personal injury kind of cases?
In law, we call this kind of a floodgates argument. You know, the courts will be overwhelmed with a tsunami of cases.
Is that one of their fears?
I think possibly. I mean, I don't find that argument convincing. Floodgates arguments always have two parts. First is an empirical prediction, how many cases? And second is a normative, a value judgment. Are these cases worth the court's time? On the how many new cases, I actually don't anticipate many new cases under my approach. It's super embarrassing to sue in a culture that blames people for being deceived. You have to have the money to hire a lawyer. It only makes economic sense to sue someone who has the money to pay a damage award, which most people don't. And you have to fit your claim into an existing cause of action. I'm not creating new causes of action. I'm just saying you have to fit it into something the law already recognizes. So I don't actually anticipate that many more cases. But more fundamentally, I reject the idea that intimate deception cases aren't as important as the ordinary tort and contract cases that consume the docket. Intimate deception can cause just as much injury as all these other types of cases. Or more.
Right, because of the very personal, part of it. Do you think that lawyers coming through our law schools in the country now are going to be prepared to handle cases like this without your book taking off? I mean, I'm thinking that if I was, deceived and went to a lawyer and thought I had a case, he would most likely say, well, I've never done this before, Mary. I've never handled this kind of case.
Or if I have, it hasn't been successful.
And it hasn't gone anywhere.
I think changing the law is going to be hard, but to me, the most important first step is to get more people thinking and talking about it. I think one reason the law of intimate deception looks like this is that people just haven't focused on it. I mean, this is the first book about how the law regulates deception.
That's what I understood.
In intimate relationships. And I think that when people focus on it, they can start asking the questions, does this actually make sense? I've been speaking at a lot of law schools, and whenever I speak to students, I always say, remember me when you wear the robes. Remember me when you're a judge, right?
Oh, that's great. No-fault divorce plays a part in the whole story here too, doesn't it? Can you explain that just briefly?
Yeah, so I think actually the most important reason why the remedies that historically have been available for intimate deception are now less valuable is the advent of no-fault divorce, which basically means you don't have to have a reason. You can just get divorced because you don't like the person anymore. Fewer deceived intimates come to court because you don't need to prove deception to escape a marriage. And sometimes when people sue a deceptive spouse, courts will say that litigation is incompatible with the existence of no-fault divorce. That argument doesn't convince me. I support no-fault divorce. I think the freedom to leave an unhappy marriage is an important advance. But no-fault divorce doesn't mean you're immune from the civil liability you would ordinarily face for injuring someone. If that was the case, then someone being beaten during marriage couldn't sue for battery because their only remedy is no-fault divorce. That's unappealing, and it's also inconsistent with the fact that almost all states have eliminated interspousal tort immunity, which is meaning in general, you can sue your spouse for torts.
Well, isn't this whole thing too somewhat based on a sexist point of view from the mostly male judges in our country?
Gender, it's interesting. So one question people have asked me is, are women more likely to be deceived? Men are more likely to be deceivers. There's not systematic evidence of that. Okay. In part, the whole area is understudied. I think that there is an assumption that men are more likely to be deceivers and women are more likely to be deceived. And that could help explain the judiciary's lack of willingness to go in. And there certainly are cases that are very explicitly gendered. So at the most extreme, there's a case where the court compares a man who lied about his job and his assets to the strutting rooster in the barnyard and says, heterosexual mating depends on men being able to deceive women. So that's a very gendered assessment of why we're not going in. So I think gender is running through it, but it's not the case that women are always the plaintiffs, men are always the defendants.
I did read a quote that I wanted to ask you about, and it says, Jill, judges have relied more on their own intuition than on seasoned or reasoned analysis. Is that something you would still stand behind as a statement of fact? Yeah,
one thing that's interesting about these cases is there tends not to be much analysis. Courts will say it's intimate. So think about the case with Paula Bonham I just discussed. Illinois Supreme Court, which is a pretty fancy Supreme Court, state Supreme Court, basically says it's an intimate relationship. The law just doesn't have an interest in intervening to stop deception and intimacy. Why not? Why should the law be interested in protecting deceivers rather than the people they deceived? Why should it be so different than outside of intimacy? So it is striking that it's an underanalyzed area of law, I think, because courts it's just common sense. And so part of what I'm trying to do is disrupt that common sense.
And it sort of boils down at one level, too, to it's the principle of the thing, right? Don't you find that persuasive?
Right, and I mean, in part, and under my approach, I'm trying to give people access to the ordinary remedies the law otherwise makes available. So we've already made a legal judgment that people should be able to sue for battery or misrepresentation or deceit. So you're just giving intimates access to a remedy that the law otherwise thinks is a legitimate remedy, where people have suffered injuries and they should get compensation.
How have you found your colleagues around the country, and you've worked in many different law schools, so you've got a lot of people you communicate with, I know. How have they responded to the book?
It's had a positive reception. I'm hoping that it will change more people's common sense views about how intimate deception should be regulated.
Mm-hmm. I bet. And do you think some of the judicial people are a little nervous about it, or
well, I wouldn't go.
Defensive? Would that be fair?
As I said, I think the first step is getting more people thinking and talking about it, and it's about radiating outwards. With the exception of the statutes banning breach of promise to marry, this area is really all judges. Even with those statutes, the real problem is how broadly the courts have interpreted it. Mm-hmm. So intervening in how judges think is a slow process that I think actually does start in law schools, radiating out.
I would think so, yeah.
Something I wanted to say that I haven't gotten to yet is, in addition to changing how courts regulate, I also think the law should improve how it regulates intimate deception before litigation begins. Most people aren't going to sue even if their chances of success improve. And it's better to avoid injury than to have a cause of action after the fact. So the book also talks about ways the law could look for opportunities to discourage people from deceiving, or to stop deceptive intimates from carrying out their plans, or to limit the damage they can inflict.
So it could, if it was changed and it became the new way of viewing this, it could be preventative, is what you're saying, in terms of intimate kind of deception.
Right. So, for instance, intimate deception generally causes less damage if it's discovered sooner rather than later.
Right.
So the law could look for opportunities to help people discover whether an intimate is deceiving them, when that could be accomplished without invading privacy, liberty, or security. So one of the suggestions I have in the book is states have public records on marriages and divorces and bigamy convictions, but they don't coordinate between states. States could consider creating a coordinated database to help people discover whether their date or fiance is unmarried, as he claims to be. And this would be a way of limiting the harm deception can cause. And I don't see it as much of an invasion of privacy because it's already a public record.
But that is one of the reasons that people have hesitated to try to find out if someone is deceiving them, because it can actually put them in some kind of legal jeopardy, can it?
Right. So courts and commentators like to blame people for being fooled, and it's not surprising. Events tend to look more obvious in hindsight. When we know he was a deceiver, it seems so obvious. Also, it's comforting to believe that only the particularly stupid and gullible are vulnerable to being fooled, because then we're safe. We're also smart and savvy. But in fact, it's much harder to spot deception than we'd like to believe, especially deception by an intimate. Even if we are suspicious, strong social norms urge us to trust our intimates rather than investigate them. And even if you'd like to go forward and investigate, it's hard to do that without the person finding out about it.
Right.
There are practical obstacles. If you follow someone or search their garbage, they may spot you. And there are legal obstacles to investigating without consent. So courts like to blame people for not investigating, but the law itself makes investigation much more difficult. If you look through someone's email or credit reports or tax returns, that's against the law and for good reason.
So if you've been deceived, don't feel badly in the sense that you did something wrong. Really, I mean, it can happen to anybody, right?
Right. One of the messages of the book is, if you've been deceived, you're not alone and it's not your fault. I can tell you that the number of extremely smart people and accomplished people who've told me the ways in which they were deceived by their intimates, I mean, it's not a reflection on you. One of the injuries actually deception inflicts is often the deceived person feels so stupid, right? In addition to all the injuries, there's this woman who found out that her husband was a bigamist and he various financial shenanigans. And she says, in addition to just the collapse of all these aspects of her life, she also feels so stupid and that people are considering her stupid when, in fact, you know, he was a master deceiver.
So she was not to blame at all, but I can see it would be very easy, I think, for people to feel, I should have been more alert, I should have known this, I should have trusted my intuition or whatever.
Now, if you feel like something is not right, I'm not saying trust blindly. Like, if you want to investigate, I'm not saying don't investigate, although be aware there are legal constraints on what you can do. Just that if in fact you're deceived, it's so much easier in retrospect to think you could have spotted it. And also, anyone who's making you feel bad about it, part of the reason they're doing that is because they want to assure themselves it couldn't happen to me. I'm so much smarter.
Well, these are all just really important things to realize and think about. Give us your website, because people may, and I'm guessing many of you will want to pursue learning more about this, find out where they can get the book, which is all over, really, right? But what's your website, Jill?
Okay. So my website is jillhasday.com. That's JILLHASDAY.com. And the book is available wherever you like to buy books, including Amazon and Barnes & Noble.
I'm going to hold the book up one more time here so people get a good look at it. But thank you so much for coming down and doing this and giving us a lot of food for thought and all kinds of both legal and personal insights as we, listen to you and get ideas. So thank you, Jill.
Thanks for having me. I
coming.
appreciate it.
Thank you for being with us. I'll be back again next week. Check out Jill's website, jillhasday.com, and I will see you next week. Thanks. Bye-bye.